We do handle a significant amount of partnership disputes. That means anywhere from two company owners to significant amount of owners who are feuding over something that's happening within the company. So based upon the size of your business and the structure, be it an LLC, a corporation, et cetera, you may have different means of obtaining results that you're looking to obtain. But the moment that there is a bona fide dispute, often companies will run into a problem of, hey, I want to sue my business partner or sue my business partner and the company. But in the interim is where there's a fear or concern. Well, for example, what happens if my partner is literally running off with the bank account, the funds from the bank account of the company, or they're self-dealing and taking assets that belong to the business and transferring them out to a third party? What we often do is in the interim, while we sue a party, we will file for what's called injunctive relief. And injunctive relief are interim remedies that a court allows, or court orders, to basically say you cannot do something pending the outcome of this case. And what we tend to get is first we'll run into court to get what's called a temporary restraining order. That initially ensures that whatever the bad actors are doing, they have to stop or they'd be subject to violating an order and be held in contempt of court, which can be civil or criminal contempt, which has penalties and fines and even jail time. Beyond that, we can get an attachment of a bank account to ensure that an individual bad actor can no longer transfer funds out of the business. And then while we have our temporary restraining orders, a judge will typically say, I want to read the arguments of both parties, and then I want you to come back in on a further date to determine whether or not I'm going to allow this type of relief to remain pending the outcome of the full case. And if you're able to get that relief, that's called a preliminary injunction, and that will typically last for the entire duration of the litigation. So I would say that if you're having a significant dispute and it's beyond the point where you're able to work it out amicably and you need to go to court, you can always sue. You always have that option. But if you're in a situation where you're seeing that, hey, if by the time a lawsuit gets resolved, which could be anywhere from 1 to 3 years down the road, I'm worried that this business is literally going to fail because of the conduct of one of the owners, then interim relief is something that you really should strongly, strongly consider. Mergers and acquisitions are transactions that happen all the time. One company's purchasing another, there's an acquisition by one company, two companies are merging, et cetera. Often in this space, we see problems arise out of the due diligence phase of a potential acquisition. So when a prospective buyer is purchasing a company, for example, typically it's done by either a stock purchase agreement where they're actually purchasing the entity itself, or via an asset purchase where they're buying the actual assets of the company, such as whatever materials and equipment, et cetera, the company has and its contracts, but they're not actually taking over the ownership of the entity itself. Regardless, there's a process called due diligence that takes place prior to the acquisition. And what that looks like is it's a review of books and records and details associated with the financial health or non-health of the business. You can see the balance sheets. You get to look at the profits and losses. You can see tax returns. And during this process, there's also questions about any anticipated litigation. Are there any liens against the business or the assets that are owned by the business? Are there any debts of the company, et cetera? And a lot of times you'll have situations where this information isn't fully disclosed or it's not disclosed properly. Now, as a buyer under New York law, you are considered generally to be a sophisticated business person when you're buying a company. So simply because you might say, well, I knew about most of the issues of the business, but not all of them, a court's still not going to say, you know what, I'm going to rescind, in other words, unwind this transaction because there was potential fraud or misconduct. However, there are instances where the sellers provide documentation that's either fabricated, completely inaccurate, grossly mistaken in terms of what the anticipated revenue goals of the company would be. And it does warrant a buyer to say, you know what, either you need to compensate us for these losses, or you need to put us in the same position we would have been in had this agreement never taken place, which would essentially mean that whatever we paid needs to come back to us. We'll take this company and we'll sell it back to you. We tend to handle a decent amount of these types of cases. They are rare to see full rescission take place. That doesn't always happen, but we've actually handled a number of matters when it does. And I think those are the issues that really come up with these mergers and acquisitions that take place.